you haven't seen Doug in the past, he was here a few months ago and did a really good program on GL and drilled down into some finer points of additional insured status and how that works, and language you need to be aware of when you're trying to contractually push risk downstream. So that was a very good program, and we're really glad that he blessed us to come back out again and do a program on the AIA documents, which were just released this April. I don't think we've seen any really flow in yet. I think that's pretty typical because the old documents are available still in the software, and most folks have sort of negotiated their changes sort of pre-canned on those a while ago, and so they're used to using those slightly modified or largely modified documents, and so we expect that these will take a little while to flow into practice because they're going to be available in the software until next fall. So, you know, this will give you some time to absorb the changes. I think most of them are not too overly concerning, but good stuff to be aware of. So he's going to drill down into the particulars as we go along. Doug's a construction attorney with Smith Curry. If you don't know them, they're a very well-known local firm. They also have an office in D.C. and you have one out the West Coast too?
San Francisco, Fort
Lauderdale,
Lauderdale, D.C., Charlotte, Atlanta.
And construction only, right?
Yes.
So a pure construction firm, which is, you know, there's some little boutiques, but they're probably one of the biggest pure construction firms in the country, I would think.
We think so.
They do a lot. Doug does a lot of work with the AGC, which is where we met. He's done some programs similar to this over there, so we really appreciate him coming out here and doing some of these for us. So he's very active in the AGC, but basically spends 100% of his time representing contractors in disputes, negotiating contracts, and providing counsel on construction, you know, issues of all kinds. So Doug has got a dual degree from the University of Kentucky, undergrad, and law degree as well. So it's double degree. So we're very pleased to have Doug Tabling. Thank you.
Thank you, Doug, for the kind introduction, and thank you all for the turn. I'm going to do my best to make sure I stay somewhere that everyone can see me and hear me, and I can stay on the camera. They are recording me to hold it against me and use it against me later. So if I equivocate, because I'm trying not to pin myself down, you never know which side of an argument you want to be on until you find out which side of the argument you want to be on. As Doug said, my name is Doug Tabling, and I'm a construction lawyer. I'm an attorney here with Smith Curry & Hancock in Atlanta. I'm a partner in the firm, and we do have offices in Washington, Fort Lauderdale, Charlotte, and San Francisco. We do work all over the country and even in several foreign countries. Before I get into the substance of this, I'm going to go ahead and beg your indulgence because I'm going to break one of the cardinal rules of presentations throughout this presentation, which is I'm going to be looking back and reading off of this or even reading directly out of one of these documents. The reason for that is that we're talking about contract terms and contract documents. And of all the presentations that are the most difficult to give without having overly textual slides and reading too much, it is about contract terms. And why is that? Well, it's because contracts don't exist in the abstract, and there are certainly contract concepts that we can discuss. But when we're talking about the very specifics of a particular contract or a particular agreement, those only have meaning in the sense of the actual words that are being used. So I'm going to be referring to some things in these documents and even reading you some passages out of them as we go along, so fair warning. Wrong button. So we're here obviously to talk about the revisions to the AIA contract documents that, as Doug said, were released earlier this year. The AIA does this revision. Real quickly before I go any further, I'm sorry, that was what I was meaning to say. But we had 4 handouts over there on the desk. If everyone has a copy of those, there are some things you might want to take a look at as we're going. You're not going to need them, but if you like them, they're there, and I'll tell you when I'm going to be talking about any particular one of them. I didn't bring a document about the document for everything I'm going to talk about today, but for most of them, and we'll see that as we go through. So as I was saying, the AIA does these revisions on their major documents roughly every 10 years. They did it in 1987, they did it in 1997, they did it in 2007, and they also did it obviously here in 2017. The new documents occasionally do get introduced in between those cycles, But once it gets into a cycle and it's been introduced, they'll then wait until the next 10-year update usually to update those things. As I said, the last changes were in 2007, and what we're really going to look at is sort of the substance. I don't want to go too much into an overview of all of the concepts of the AIA documents. What I'm going to do is talk to you specifically about the things that have changed between the 2007 versions of some of the major contract forms and the 2017 versions of those same documents. Pretty soon, everyone's going to have to move to the 2017 documents because, as Doug said, eventually the 2007 versions will expire. So these are the documents that are going to be retired, the ones that are being replaced. And they include the A101, which is your standard agreement between an owner and a contractor for a stipulated sum, essentially a lump sum design bid build kind of project. Also the A102, which is more of a cost plus with plus a fee with a guaranteed maximum price, or a GMP, as we all know it. The 103, which is a cost plus without a GMP, and a number of others. The 105 for residential and small projects, the 107 for projects of a limited scope. The big one is the A201 because, of course, that's incorporated into and made a part of so many of these other documents, which are the general conditions of any of the construction agreements, including all of the 100 documents and also the 401, which is the subcontract document. The general conditions of that subcontract document are the A201 general conditions. The 401 subcontract is going to be sunset. And so the A documents, for those of you who may not be familiar, are all of the construction agreements. So those are the prime construction agreements and even the subcontract agreement. The B series are the design agreements. And a number of these are going to be sunset as well and have been updated and revised, including the standard agreement between an owner and an architect, which is the B101. Some of the others that are just variations on that same thing, but they're all owner and architect agreements. And then you've also got the C series, which are an architect's agreements with its sub-consultants, its engineers, maybe some other architect that brings in to do a specific part of the work. The prime, I shouldn't say the prime, it's a bad mix of words in this conversation, but the typical or most often used of those is the C401, which is the agreement between an architect and a consultant, also for sustainable projects. All of these documents are going to expire and will no longer be in use, or available for use, I should say, at least through the AIA software, as of October 31st, 2018. So you've still got more than a year before all of these documents are going to be no longer available. So as Doug said, most of these documents have been tailored or modified by the folks who use them in a way that suits their purposes or suits their liking. People who do use these documents are going to have a little over a year from now, it's about a year and a half from the time that they came out roughly, to get used to the idea of using the new ones. Now, I submit to you that you will still see the old versions rolling around. In fact, within the last year, I actually reviewed a prime contract that was the 1987 AIA general conditions that someone had revised back then and kept tweaking since then, but never really changed. What they had managed to do, I mean, they quite literally just had someone re-enter the thing, but I recognized it enough to know that this was the 87 version of the AIA document. So that will still happen. But I'll ask just a quick question. How many of you have a subscription to or access to the AIA software or the AIA website to use the AIA contract documents? Okay, a fair number of you. That's all going to be, the software is going to be going away. It's all going to be going into the cloud. It's all going to be on the website and online. It mostly is now already. And eventually when you log in to do that, you're only going to be able to find these to start using. Now, I know that Doug said I've got a number of his colleagues here from Sterling Seacrest. Congratulations to all of you, by the way. The last time I was here, that hadn't happened yet. So, but I know we've also got a number of contractors in the room. Do we have anybody who works for a developer or an owner of any kind here with us? Okay, we've got one. I just want to make sure that I'm on my P's and Q's. I don't want to hit too hard on any particular topic. Do we have any designers, any architects or engineers or anybody who works for a design professional? No, and so most. Yeah. Okay. What kind of design work do you folks do?
Medical.
Okay, medical
Dental.
facilities and Okay, and your architects?
We're bad. We're too bad.
Architect, engineering, okay, great. Well, so we'll,
Architect and builder.
oh, I'm sorry, you're an integrated design builder doing the architecture and the building on things. I see,
We
great.
fight with ourselves all day.
Well, I'll be happy to help you. Just let me know which one of you want me to fight with, and I'll. So all these are going to expire as of Halloween 2018. Any questions about sort of the structure of how these documents work for those of you who are new to the AIA formats? All right, so this is more specifically what we're going to talk about today. I'm going to talk about the B101, which is the standard agreement between an owner and an architect. Now, I know we've got mostly contractors in the room, but I think it's still very useful for the contractors to understand what is in the agreement between the owner and the designer that is related to the projects on which they're working. That is, the left hand, it often helps for the left hand to know what the right hand is doing. You just have some concept of how all of these moving parts are working together and what their motivations might be based on the other agreement they have with the owner vis-a-vis how they're interacting with you and and how those things might interact. We'll talk a little bit about some of the major moves and the restructuring of some of these documents and then a couple of new documents that you have. And then I'll talk about some of the specific changes in the A101, which is the standard agreement for a stipulated sum between an owner and a contractor, and the general conditions, and also some things that are uniquely changed in the A102 with the GMP. Okay? So let's get right into it. We'll talk about the B101, and I'm going to, as I said, I'm going to hold on to my copy here, just for the sake of having to read a few things to you. But these documents, there are redline versions available of these that show all the changes. They're available on the AIA website. I've also got them myself. I'm going to give them to Doug and Katie, and I'm sure that if you can ask me for one, I'd be happy to email it to you, or I can give them to Doug and Katie. They can send it to all the participants. This is not one of the documents that you have in front of you. But so just right off the bat, the initial information for the project, things like the owner's program description, the program for the project, and physical characteristics, the budget for the work, and all of these that used to be in an exhibit are now going to be right in Article 1 of the agreement. They just moved those in. There's not a whole lot of terribly substantive changes to those ideas, but they've all been moved into the document. The B101 also elevates the possibility of having a sustainable objective into its own subsection in this agreement. This is sort of the AIA's. They've got a certainly both an interest in and they're working more and more toward bringing sustainability to all of their design, all of their design documents. You're going to see this more and more in all of your construction agreements as well, and we'll get to that when we get to the construction agreements. But it brings the idea of having a sustainable objective and defining that right into the terms. So let's see, it's 1161, which has not only, which refers more particularly to one of the documents you do have in front of you, which is this E204, which is a brand new AIA document, the Sustainable Projects Exhibit. So they are dedicated enough to these sustainability notions. They've created a new exhibit that talks about what the objective, how you're going to measure that, what the plan's going to be, what certifications we're going to have, whether it's going to be LEED or Green Globes or Energy Star or whatever sort of certification they might be trying to achieve. All of that's going to be spelled out in this exhibit that may very well be, as you'll see as we talk about them later, incorporated into one of your construction agreements, portions of it at least. And so the design agreement is going to have this as a potential exhibit, and all you have to do if you is in the B101, if you identify that you want it, then it just becomes incorporated. In the B101, they've added some language that obviously, one general point of note I want to make is that all of these things, as always, are negotiable, right? So none of this is something that you can't change or work around, but the documents always have some sort of default presumptions and things you need to be aware of that are in there that you need, if you haven't set up your project this way, you might need to change. So for example, the B101 assumes that the owner is going to engage the geotechnical and civil engineers, and it also presumes the architect is going to engage structural, mechanical, and also the electrical engineers. And that's now spelled out very specifically in here, rather than having the parties have to determine those separation of responsibilities and include them separately in some kind of a scope of work exhibit. It's going to be in this document. Well, what does that mean? It means that not only do you need to be careful about what's going in the scope of work, but you've also now got to go back into this document, and if that's not the way the project is going to be structured, make changes to this, otherwise you're going to have conflicts. There's also a provision that instructs the owner and the architect to agree upon how they're going to transmit and use electronic documents, especially digital data and BIM models. It's going to incorporate a separate document that lays out who's going to be responsible for what, when ownership of information transfers from one to the other. For the most part, it disclaims any responsibility on the part of the designers for anything that is in those documents. They're going to rely still on their stamped drawings as they have in the past, and not allow owners and contractors to rely very much, if at all, on any of the digital information. I don't know how much longer that's going to last, or how much longer they're going to be able to forestall that. I mean, it's the change in the industry to electronic design documents and work is happening. It's here. It's already happening, and it's at some point that's going to have to change. It probably won't, at least for the next 10 years, or until the parties themselves have to make changes themselves to what's in here. But I suspect there's going to be quite a bit of resistance and pushback on that. That's all Article 1 of the B101 into Article 2. There's a new part of Section 2.1 that requires the architect to be properly licensed in the jurisdiction where the project is located. Who would have ever presumed that was not already in the architect and owner's agreement? The architect was going to be licensed to do the work in their jurisdiction, right?
It's in every agreement that we sign.
It's in every agreement that you sign.
Yeah.
But you're a contractor, not a designer. You've got to be licensed.
Yeah, I'm surprised that's not already.
Well, but remember, these aren't the Construction Institute of America, Contractors Institute of America documents, these are the Architect Institute of America documents, or the American Institute of Architects, excuse me, get that right. So, what this does is, obviously an architect who's performing unlicensed work has all kinds of other problems under the statutes, and they've got obligations to do that, just statutory, and I can't imagine any reputable architect who would violate that. But now it also becomes a breach of their contract. In the past, although not having a license was probably an implied term, and there are some jurisdictions you could have alleged that not being licensed would have been a breach, it's now spelled out very clearly that they have to be licensed in the jurisdiction where they're located. It took to 2017 to make that happen. So here's some changes to the scope of their basic services. The architect, they've added a provision saying that they're not responsible for an owner's directive or substitution, or from owner's acceptance of non-conforming work unless they've got a written approval from the architect. So they're disclaiming liability for anything the owner has decided, no, we're going to accept it, or no, we're going to make a change, unless they get something written from the architect saying we agree with you, or we agree that you should accept that, or there's going to be more non-conforming work. There's also a provision saying the architect services related to substitutions are now treated as additional services. So even if the construction contract in the design program presumes or assumes from the outset that there could be substitutions, there are perhaps alternates or some options within the specs. Any services they're going to have to provide related to those substitutions are now part of what is included in payment for additional services that are outside of their typical fee. They also no longer are going to pay for reproduction of proposal documents, they're just going to help you owners distribute them. This change to 3631 about payment, saying that they certify that the contractor is entitled to the payment, the amount certified, seems like something important, but quite frankly, I'm not sure that it really is a significant change. If they've certified the amount, then to me that suggests that they've certified that you're entitled to that amount. This spells that out a little more clearly, and I think there are some things both in these documents and in a number of documents that we see, and this is not a bad thing, that spell out in very express and explicit terms things that are true anyway. That is, things that are sort of the default position of the law, that the law is going to apply into or read into any one of the agreements. But it's also not necessarily a bad idea, just for everyone's benefit, to have them spelled out very clearly and not have to have the discussions about whether or not around the margins these things are implied or not, or what exactly they imply. Stating them out expressly, even if they already exist by operation of law, is not really a bad contracting practice. The challenge with that is that it makes the documents longer and longer and longer, which, I don't have a particular concern about, but I live with these things. The A201 is now up to, gosh, 36 pages, plus a few more for exhibits, and that's just the 201, forget the documents on which it relies. And for whatever reason, everyone still has an aversion. They get a 30-page document and they think, oh, there's got to be something in here that's trying to get me. If this is more than 4 or 5 pages, then it can only be that because everything in here has to be bad for me. I think some of these things are expanding, and that's not an unreasonable presumption. But it's also true that a number of the things that are being written and added into the contract documents more and more are just restatements of what we all sort of think and know to be true as a general matter. Anyway. This one is, I think, something reasonably significant. 3643, and I'm going to read this one to you particularly because I think it's interesting. What it does is it displays in an even more emphatic term than it did before what the architect has no responsibility for what might be in submittals. And here's exactly what it says. This is the new language. The architect's review shall be for the limited purpose of checking for conformance with information given and the design concept expressed in the contract documents. It's not a design, it's concepts. And the architect shall be entitled to rely upon, and here's more new language, and shall not be responsible for the adequacy and accuracy of the certifications and approvals performed or provided by a design professional who's preparing these submittals. So it's being even more emphatic about explaining their liability for anything that has to do with something that's in the submittals. And it's doubling down on the notion that the design they're providing is not a complete design, frankly. It is a concept. It is a document that demonstrates an intent that must be in some ways inferred or understood with more specifics. 366114 includes more qualifying language regarding that's a certificate of payment. This is for final payment. It includes new language, and here it is. To the best of the architect's knowledge, information, and belief that the work complies with the requirements of the contract document. So it's qualifying whether or not the work that they're certifying is properly done and appropriate for payment is actually properly done. If to the best of their knowledge it is, but they're trying to temper down the amount of responsibility that they've accepted for certifying that work is complete. Here's something new in the owner's responsibilities. In the past, the AIA documents required the owner and the contractor to communicate to each other through the architect, which was a little bit unusual, especially in the sense that the architect was very clear on making sure that it wasn't a party to the owner-contractor agreement. What the documents now say, and this change has been made throughout the AIA documents, you'll see it in the construction documents as well, is that they have to include the architect on those communications, but they're not required to communicate through the architect. So this is at least taking that hurdle or that stopgap out of the process. I'm not sure this is something that everyone necessarily often complied with. It just was in some ways impractical, but that's the new language. New language in Article 9 about terminating or suspending a design agreement. The architect can recover the cost attributable to the termination if the owner terminates for its convenience, or if the architect terminates due to a 90-day or longer suspension of its work. And that's really the change is that or. They no longer, however, can recover their lost anticipated profits on the work not performed in the event of a T4C. They're going to get their termination and licensing fees agreed upon when the contract is signed. So in both the design agreements and the construction agreements, and again, we'll get to this, but the T4C concept was one that was probably one of the most unusually contractor-friendly provisions of the AIA documents, and that is that, even though I'm talking about the design agreement, I'll skip ahead to the construction agreement and tell you this. The old documents, if there was a termination for convenience, a contractor was entitled not only to the cost of, or the value of the work, the cost of the work they had put into place, and a reasonable markup for overhead. They were also entitled to their lost profit, not only on the profit for the work that they had not yet been paid for, based on that cost, but also the lost anticipated profit on the remainder of the work. That's no longer the case in the AIA documents, and that's new. It's a reasonably significant change. I think it is bringing things back in line with what I would perceive to be generally the industry standard. I think that's pretty typical. But as Doug mentioned to me in the hallway, in a market like this one where some contractors are truly having to choose which a couple of available projects they might select to do, this might be something worth negotiating back to the other language, might be something worth keeping use of the 2007 versions for. for a little while, or at least trying to get that language, put it back into the 2017 version. Because if you're reasonably uncertain about whether or not one of these projects might get terminated for convenience, this is going to be, you know, the lost profit on future work that you're going to have to, you know, you got to choose one or the other, and the other one's not going to wait around for you to find out whether you've been terminated on the one you chose, is something you're going to have to consider. A few other miscellaneous provisions and changes in the design document. It clarifies that a party that receives confidential information is free to disclose that in order to comply with the court order, some kind of a subpoena if there's a dispute and they're getting a request from some third party or non-party to this agreement. They've got confidential information, clarifies that they can produce that. It also provides they can give it, they can distribute it as necessary for other individuals, perhaps sub-consultants, to do whatever work they might need to do. And there's also this savings clause talking about the event of a provision is deemed to violate any law, and it says something to the effect of, in the case that any one of these terms is deemed to be void or unenforceable for some reason in whatever jurisdiction. Because the challenge with this, as with all contract documents, is this is one single standard document for use all over the country. And I've given in the past, and I'm sure we'll give it again because it doesn't change. It doesn't. The point never changes. Another presentation in which I would tell you that if you're doing the exact same project for the exact same owner with the exact same team of key subs and specialties, whether it's an industrial plant in a rural area, or whether it's a retail space in a suburban area, or whether it's a mixed-use facility in an urban area, and you've already worked out all the kinks the first time, and the owner wants to go do another one somewhere nearby but across state lines, and you're using the exact same construction documents, you're doing it wrong. These things don't, not every one of the provisions in this document is going to be interpreted the same in Georgia as it will be in Florida, as it will be in South Carolina. That's just the reality of it. So, as a way to try and mitigate that risk, and using a standard document that is one size fits all for all over the country, they put in the savings clause that says in the event that any of these provisions are deemed to violate a law of this state, then that doesn't affect any of the other provisions of the contract. That is, one bad apple in this bushel isn't going to make the entire agreement void or unenforceable. I think that's generally enforceable. That is, I think that's generally going to stand up. That if there's a particular section or a particular part of the agreement on some substantive fact or issue that's not enforceable, that's not going to necessarily make the entire contract. Now, I'm starting to twitch up here a little bit because lawyers never want to speak in absolute terms. So I'm going to try hard not to qualify everything I say with generalities and typicallys and usuallys, but it's an old habit, and I just, they ingrain it into you. But the other thing that it says, and this is a little bit different, is it says, to the extent that one of these provisions sort of overreaches. So imagine an indemnity provision that requires you to indemnify another party in a way that is too broad or is impermissible under the law of a certain state. What this says is that the provision would be dialed back or read down to the furthest extent that the law permits in that state. Well, that part I'm not so sure I'm certain it's not enforceable in every jurisdiction. That is, in some jurisdictions, they're not going to allow courts to what we lawyers call blue pencil, which is sort of scale back or dial something back just to the limits. If on a scale of 1 to 5, you're at a 4, but the law only allows 3, they may not just take it from 4 to 3. If it's at 4, then you go on to 0. You don't have the provision anymore. It's a little bit of a distinction, but it's definitely a difference. There are obviously pros and cons to using these standard forms. One of the drawbacks and the cons is if you're using them consistently in the same document in different states, you need to think about whether or not every provision in there is going to be interpreted in exactly how you want it to achieve the goal the two parties have in the state in which it's being used. Now, one way to deal with that, of course, is to try and have some consistency in the choice of law provisions you put in your contract. Because if you're going to tailor it to be enforceable under a certain state's law, then having a provision in the document saying this document shall be interpreted under the laws of the state of Georgia or Florida or South Carolina or whichever state you choose, that helps. But those provisions are not always enforceable in every contract in every state. That is, some states will say we're not going to let you come here from somewhere else and have an agreement to work with, mostly contractors and mostly people who are from our state, who live in our state, who are residents of our state, who we know how to best serve with our statutes and our laws, and decide that you're going to impose some other state's law on a project being built here. Now, that's the minority rule. In most states, they will allow you to do that. But again, these things are, they're moving parts and pieces, and you've got to consider all of those issues together when you're talking about these savings clauses and choice of law provisions and things like that. Any questions about that? Does that all come together? All right. Quickly, the rest of the design agreement, when the compensation is on a percentage basis, it's going to be based on the most recent budget for the work. After one payment is made, you're not going to look back and make any adjustments backward and try and claw back any money. It'll be the credit on the percentage that we go to the next time there's a payment application, but in between payouts, just because you change your budget doesn't mean we're going to be sending any money back. And that's another design agreement. Any questions about that before we get into some of the insurance provisions and the construction agreement you guys are probably more interested in? Okay. So, major moves, restructuring, and new documents. The most fundamental structural change, I think, in the new documents is the way that they're now handling the insurance requirements. So one of the things you have in front of you is one of the new insurance and bond exhibits. And that is, you'll see it's titled Document A101 2017 Exhibit A, Insurance and Bonds. Now, there are different exhibits for contracts depending on whether you're using it as your prime agreement a 101, a 102, or a 103. They don't differ much in substance. They differ a little bit in terminology to marry themselves up to the terms that are used in the other documents. But the substance of them, you don't need to, they're not fundamentally different necessarily. There is some terminology differences between them just because of the way that those documents refer to payments and the parties that are involved. But this is a good example. So what you've got here is the exhibit for the A101, which is the stipulated sum, sort of lump sum prime contract agreement. And here are a few of the key provisions of this. First of all, it defaults to the owner purchasing all risks, builder's risk insurance, unless the obligation to purchase builder's risk insurance is passed on to the contractor, or that is affirmatively made. The default position is going to be the owner is going to purchase project-wide all risks, builder's risk insurance for the project. Throughout the document, there are places where you can identify sublimits for specific causes of loss. And it was a way to perhaps manage an insurance program or manage premiums. And maybe you want a bigger limit for just certain risks, but not that high of a limit for other risks. And rather than having a higher limit for all risks, which would then increase your premiums, you can modify those a little bit. You can play with those a little bit, break them out. The owner is going to be responsible for the losses that are within the deductible or the self-insured retainage. There are some optional insurance provisions in here that are going to have to be affirmatively selected and noted for things like business interruption, site and cybersecurity. There's a provision here about the requirements for certificates. In this document, there's going to be a disclosure of what the deductibles or the self-insured retainage are going to be. All of the limits are now fill in the blank. They're not going to be defaulted to specific dollar amounts. I'm not just going to say $1 million for this or $2 million for that. These are all going to have to be determined and negotiated and included in this exhibit. So they're going to be fill in the blank. There are a variety of types of insurance that are identified in here among which to choose. You're also, if there's going to be bonds, this not only deals with insurance, it's also going to deal with bonding requirements. So there's going to be a requirement for bonds. This is where you're going to elect that requirement. It's going to, you're going to insert the penal sum of the bonds in this exhibit. So what this really does is it moves most of the insurance requirements out of the A201 and into this exhibit, out of what was Article 11. The concept behind this is a couple of things. Number one, it's more flexible in that it doesn't have as much sort of default requirements that are already there, but it's going to require more work on behalf of the parties to decide exactly what coverages they do and don't want, what those limits are going to be. So you're going to find and you're going to see that you're going to be spending a little more time not just changing the old default, but having to put together an exhibit like this for each one of the documents. Some sophisticated owners do a lot of work. are going to go ahead and prepare their standard version of this, and they're going to just sort of use that repeatedly. In cases where you've got the contractor having the opportunity to provide or to propose the contract documents, that might also be the case. But when you're talking about the owners that many of you work with and for, that are only building something perhaps occasionally, they may not, you're going to have to work with them to get this completed, rather than just relying on much of the default that was in the old agreement. One of the things the AIA says they like about this is that it makes it much simpler for someone to give Doug the review, because rather than giving him the A201 and making him feel like, well, I know where Article 11 is, I know where the insurance requirements are, but I also feel like I need to go through most of the document to see if this thing has been revised or changed or added some odd insurance provision in one of the other articles, or where do I find this? I mean, someone as experienced and sophisticated as Doug or many of the others of you here in this room would know exactly where to go in the AIA documents to find the insurance requirements. I submit to you that not every agent and broker is quite ready for that. And so this should be a little bit of a more streamlined process. At least that's the intent. However, I'll suggest to you that it really isn't going to change very much, because Article 11 still exists. One of the other handouts you have is an excerpt from the red line version of the A201. And so if you see the one that says near the top, Article 11, Insurance and Bonds, okay? This is just a few pages out of the red line version of the A201, and you can see how much has been taken out of here. I mean, much of this has been deleted, and it has all been moved to the exhibit. However, there is still some real meat here, and things that are important for agents and brokers and risk advisors and even attorneys to be aware of when you're talking about insurance. If all you do is send someone this exhibit and say, I want an opinion about whether or not our insurance coverage complies, whether we can get this coverage, whether we are fully compliant with our contract, you're doing it right. You're still going to need to have them look at what's in here. Now, they're for different purposes, but for example, you've got things like the notice of cancellation or expiration of the owner's required property insurance and the contractor's right to buy their own in the case of that happening. That's something you're going to want to discuss with your agent and work with your agent on. There's also, of course, I think the waiver of subrogation is still, there it is, 11.3, the waiver of subrogation is still in here. That's an important material term. That's going to be something that you're going to need your risk advisors to be looking at and thinking about in terms of your policies and your insurance program. So that's another key and important part that's still here. Adjustment and settlement of insured losses is something else that your agent is going to want to know is in your contract when they're advising you. And about adjustment and settlements of, and loss of use, business interruption, etc. So just because they've moved this to the exhibit, and of course, you know, I'm trained to be cautious, but I'm not being overly cautious here. I really don't think. And Doug, tell me if you disagree with me. But just saying that exhibit is not going to be enough. You're still going to need to look at what's in that Article 11, any changes that may have been done to it, or at least know that it's still the standard language with which you're comfortable and familiar. Okay? So when you hear people telling you, or you hear when folks talk about the documents, that this insurance exhibit can be easily transmitted for review, well, that's true, but it's not sufficient. Now, instead of sending one document, you're going to have to send two. Chances are you're probably doing that anyway, very often in these documents, because they're not just always the plain standard documents. There's some insurance exhibit that most owners are going to have, or even contractors for subcontracts. I don't want to be too specific about just owners and contractors. This happens with contractors and subs as well. There's going to be another separate exhibit that either changes, modifies, adds detail to what's in there. But that's one of the major structural changes, is that all of that's getting pulled out and put into this exhibit. Any questions about any of that, or any comments or thoughts that any of you insurance pros in the room might have that
we're happy to find the provisions that we need to locate, and this probably doesn't change that at all. So, you know, we're happy to take the document in whatever form is most convenient to you, but certainly this point is well taken, that, you know, you can't really do a review with just the exhibit that they've created. We need to have Article 11 to make sure that it works. But typically, we're also looking at indemnity provisions as well, so we typically get the whole bundle and
Right.
and work our way through it.
And the indemnity provisions are still going to be right in the general conditions as well. Questions about any of that? Okay, a few particular things, one more thing about insurance, and this is in the A201, about the notice of cancellation or expiration of the owner's required property insurance. The owner's going to have to notify the contractor within 3 business days if they know they're going to have an impending cancellation of their property insurance. A contractor can suspend the work until the lapse is cured and is entitled to recovery for that delay. They can also purchase replacement coverage that would be a change to the contract and allow that to be reimbursed. All right, the other new document, and I referred to it a little bit earlier, we'll talk about a couple of the particular provisions of it, and that is the E204. These things all look exactly the same, which is the Sustainable Projects Exhibit. It's optional. It's going to establish what services the architect, for the architect, but also for the work with the contractor on achieving some sustainable objective. So it really relies on 3 things. First is the sustainable objective. What is the goal of incorporating the sustainable measures to achieve a sustainability certification? Here in this next section are the sustainable measures, the design, the construction element, the sustainable processes that are going to be used to achieve this objective. And here's the plan. This is a new contract document to identify what the objective, the measures, the strategies are going to be for achieving some sustainability certification. So this is all about energy efficiency and LEED certifications, and it's adding more detail and specificity to what the architect and contractor's obligations are going to be to the owner to achieve that sustainability certification, okay? It should identify some kind of a rating system to point to what certification they're talking about. The parties are going to agree on the limits of the various services of the architect, and after which some of those are going to be additional services. This is going to be part of defining the scope of an architect's obligation for providing sustainable design. It's also going to end up providing some of the scope for a contractor's responsibility for providing constructing a sustainable project. So there's a mutual waiver of claims for consequential damages resulting from a failure to meet the objective or one or more of the measures, which is, I think, important, because the consequential damages are really where the damages from this flow. That is, imagine an owner that's developing some sort of a multi-use or maybe a condo project. And one of the things that they've told all of the people who are buying into this building is that the building is going to be LEED Gold, and every unit is going to have all of these sustainable elements to it. And then what happens when that's not achieved? And because of that, people who have maybe, because the market turns a little bit, have decided this is their out to get out of their purchase agreement. That the breach of the failure to provide me the sustainable unit that I thought I was going to get is a breach, and I'm going to get out of my purchase contract. Well, that would be the kind of consequential damage that this document waives. So be very careful if this document gets incorporated into your construction agreements, not to allow this waiver of claims to be removed, because that's where a lot of the real risk is, and frankly, a risk that is not, I don't believe in most projects worth taking on for the kinds of margins you're probably going to be making on these projects. Okay? There's no guarantee by anyone that the sustainable objective is going to be achieved. There's no relationship between the contractor and the architect concerning any of these items. So what it's really laying out is a scope of what has to be, what's the right word? Attempted, intended. I mean, it doesn't require, that is, it's going to lay out what we would traditionally call design specifications rather than performance specifications. And when it's not, what it does is it limits the requirements to doing to designing to the owner's program and to constructing to the design, but not to promising any particular performance outcome based on what these certifications might require in order to be achieved, or some particular energy efficiency standard. Now, those might still be in the specs of your documents, but they're not going to be, by default, a part of this. Does that make sense, the distinction between the performance outcomes and the design scopes? Yes, sir.
Yeah, but couldn't they still pin that on the contractor?
Well, in what way?
Yeah.
Yes is the answer, but
The, failure to meet the sustainability goal. I mean, ultimately, it all flows down to us in the blame game.
sure.
So,
Well,
You know.
blaming it on you and pinning it on you are different things. That's what I'm here for. But certainly,
We're definitely gonna blame it on you.
certainly they're probably willing to blame it on you. Quite frankly, I think this is a little bit helpful in helping to clarify the fact that your responsibility is going to be whatever design. You're only accepting as much obligation to meet performance criteria as you're otherwise accepting in the document, either through some contractual provision to which you're obligating yourself. Yes, we are going to get this building LEED certified platinum. And if you obligate yourself to that, then you're going to get pinned for it. But absent some affirmative obligation you undertake in order to make sure that a design is going to achieve that result, and this is a very scary thing, and I'm seeing this more and more in contract documents, is owners putting in their construction documents provisions requiring a contractor to certify that the design is sufficient to meet the owner's intent, which is really absolving the owner. It's sort of a reverse Spearman doctrine. It's absolving the owner and the designer of whether or not the documents are sufficient and putting that on the contractor. These are all things you need to be very, very careful about, and maybe design risk being undertaken by contractors might be something we talk about in a future program someday. It's something that's very nuanced and very complicated, and frankly is something that, as often as possible, owners will try and push into construction contracts. So, clarifying what your scope really is and what your performance obligations are vis-a-vis the design criteria, the design specifications, the design drawings, and whether you're obligated simply to build to the design or to achieve some performance outcome is really going to be part of what it's going to be somewhere else in the document, somewhere in the scope. And why do owners do that? Why do they want to push that down to contractors? Well, there are a few reasons. Number one, usually by the time that these design issues finally come up, very often most of the designer's fee has already been paid, and they may have somebody around doing some inspection work, but they've got retainage and a contract balance on a contractor that is a much more lucrative and simpler place to withhold payment or to keep the money to try and fix these problems. They also probably see a contractor who may have a certain amount of equipment or a certain amount of capital in order to maintain their licensing and their bonding and all the other things they have to have be capitalized in order to make. Typically designers aren't very well capitalized. They've got their office equipment and some software that they don't have a lot of extra money in the bank or sophisticated equipment that is going to be collateral for those damages. And they're probably, they've got errors and omissions insurance, but it might not be enough. And it means they're going to have to go through the architect to their insurer to get at that rather than going straight into the contractor's pocket. I think one of the other reasons is that they're still dealing with the contractor at that point. And so when these defects come up, they want to be able to deal with design problems with the party who they're talking to and seeing every day. It might not be your fault, it might not be their fault, but it certainly isn't my fault. I hired the two of you to figure this out, and you're the one who's here, so help me fix it. And we're going to pay for it, you're going to have to help me make that happen, just so that you can get along. And they also know that sometimes frankly, they know you're willing every now and again to have to take a little punch in the gut in order to get on with the work and get the rest of the project done smoothly, rather than having a big problem along the way. So there are a variety of reasons why that happens, but yes, sir.
So does this still limit the designer's liability to the cost of design? Is that still part of this?
That has not changed in the design documents yet. They've still got a limitation of liability in their agreement. Yes, that hasn't changed. All right. All right. Changes in the construction document. So here's now in the A101. This is the prime agreement for a stipulated sum or a lump sum. The old spot, the old documents had a place for the date of commencement. You just had to insert what it was going to be or how you were going to achieve it. Now, what they've done with these documents, the general matter, is they've gone to a little bit more of what I would call a sort of check the box style form of agreement. And you don't have this one in front of you, so I asked this if I was looking for it. I can get you this one, but this is not one of the ones you have in front of you. But what it does is it allows you to check the box to pick which of either your own date, but the options that it gives you are, which are not unusual, the date of the agreement, a date set forth in a notice to proceed, or some other date that's established by some other trigger, or just a date that you insert yourself. It expressly provides for some interim completion dates for certain parts of the work, and it provides for liquidated damages for failure to achieve substantial completion. So, and that's new. I mean, to have an express provision for liquidated damages for failure to achieve substantial completion, which is something that was very often inserted into these documents, but it's something that's here now as a default term. It provides alternates to be accepted after the agreement is signed, establishes the pricing conditions for those acceptance. It puts in more space for terms and conditions related to liquidated damages, and it also provides the opportunity to include a space for bonuses or other incentives. Now again, these are not going to be included by default. They're going to be things that are going to be elected and chosen to be inserted, but the language to do so is already in here. Rather than having to insert them separately or in whole cloth or to use some custom language, they're going to have some default language in here for you to choose from to make those things happen. On contractor payments, it includes, one of the changes is it's going to reduce the amount of any progress payment for an amount which a contractor doesn't intend to pay a sub or a material supplier. So if you've got some dispute with the sub about what you're going to pay them for whatever reason, rather than holding that money yourself, this is going to expressly say that we're going to reduce the prime contract payment by that same amount. We, the owner, are going to hold it for you until you're ready to pay it to the sub, rather than you holding it for yourself from them. It includes a space to insert an amount for retainage, this is one of the few places where it does remind you that retainage might be limited by governing law. Some states do have a limit on the amount or in the situations or in the timing of which retainage can be held, whether it's a cap at 5% or whether it's a cap on retainage after the project is more than 50% complete, which is sort of the typical statute you might see. There's a variety of different ways the statutes can do that. It provides, and you'll see where I keep saying space to establish or space to place. So that's, as I said, sort of the new concept. They're putting in these provisions where you can elect to include them. If you add something substantive to that spot, it's going to then become one of the terms. It isn't by default, but it will if you just add it. Yes, sir.
When you start holding money, if an architect starts holding money from the contractor, which is supposed to go to the subcontractor, in a lot of ways, aren't they kind of creating a contractual relationship now with the subcontractor?
No, I don't think they're creating a contractual relationship. I think what they're doing is they're saying that until you've worked out your dispute, we're not going to let you, contractor, perhaps use this money for some other purpose besides paying the sub. And then when you do get your next payment, you don't have enough to pay the sub, which you owed them for the last application, plus the new application, plus all the other subs. So there's a pretty good disclaimer in all of these documents. The architect has no contractual obligation, responsibility, or liabilities to any other party other than the owner, no matter what anything else says. And it'll say, notwithstanding any other provision to the contrary, we don't owe anybody any duty at all. There's no third-party beneficiaries. It's certainly going to cause some, I think, challenges in communication between contractors and subs, because it's going to encourage subcontractors to be going around contractors to owners and architects, encouraging them to decide whether or not they're going to withhold payment, how much they're going to withhold, what they're going to pay to the contractor. Because the contractor's obligation is going to be to pay what they get through and to tell you, or to send back what they don't get. And so it's going to create, I think, a little less stratification in the tiers of the contracting parties. All right, so all of this is new stuff on retainage. Termination or suspension. it includes a place to insert what they call a termination fee, in case you terminate for the owner's convenience. So this is sort of a new concept. The old concept was simply the cost of the work plus whatever the termination costs, which is the demobilization cost probably, a reasonable markup on the cost of the work that had been performed but unpaid, and the anticipated profit on the yet to be performed work. There's a new option now, just simply to just decide, we're going to just make it a termination fee. If we terminate you for your convenience, we're going to pay your cost plus X. And that can be a percentage, it can be a lump sum, whatever it is. Again, this is not a default term or a term that is absolutely going to be the way that terminations for convenience are compensated, but it is a new option that is already spelled out that you can elect if you so choose.
So that may be kind of middle ground between the old version and.
It's another way to look at it. I mean, depending on the project, the owner, and how they prefer to handle it. I mean, sometimes they want a sum certain, and they want certainty. They want if we terminate for convenience, we're going to end up paying X, and we want it to be the same amount whether we're 10% of the way through the project or 90% of the way through the project. We're just going to have, perhaps a contingency set aside for that possibility, and it's going to be there. And at any point, we can exercise it if we want to. Okay, so enumeration of the contract documents. Obviously, it's going to include this new Exhibit A, this insurance exhibit, as one of the contract documents. It also provides for the electronic design documents agreement to be incorporated into the construction documents, and it allows them to check the box for the option of using this new sustainability agreement. All right. That's the 101. I'm going to go to the. Anybody have questions about that before I go on to the 201? The general conditions, and the general conditions, of course, apply to prime contracts and subcontracts. This is another one of my favorites. In addition to the architect requiring to be licensed, it requires the initial decision maker, which is by default the architect unless you choose someone else. They now actually have the requirement to be impartial and act in good faith. Evidently, they didn't have that obligation before. It adds another one of these same savings clauses that we talked about before, and I won't belabor that point again, but that's now in the 201 as well as the design document. It allows for electronic notice if a method is included in the agreement, but notices of claims still have to be delivered by certified registered mail or by courier, providing proof of delivery. It sort of relieves all the parties for liability if any other party relies on digital design work or a BIM model without having agreed to the digital protocol, the E203. I don't particularly care for that provision. I don't mind that it has the release of liability, but saying you have to use this agreement as your version for doing that, to me, is a little too in love with your own documents. I would make this an option, but I think it would be better. There's no reason why, especially a sophisticated owner and designer might not have a separate agreement of their own on how they're going to handle electronic design documents. Changes to an owner's furnishing financial assurance. After the work started, they're only going to have to furnish that evidence if they fail to make a payment or if there's a reasonable concern identified in writing, and I assure you that whatever reasonable concern you have that you've identified will not be considered reasonable by the party trying to withhold their own financial information. Or if they change the work, materially changes the contract sum. Who knows what percentage of the work is a material change to the contract sum?
10%. Over 10.
Sure. Any one of those might be true. I have no idea. I don't think that there is really a definition of that, which makes these last two parts which makes these last two provisions helpful but not really useful, because by the time you get to the point of having a dispute and proving what is a reasonable concern or a material change, you don't need the financial information anymore because you're already way past that. All right. There's new provisions concerning confidential information, allowing the contractor to disclose it to the people who need to know. A contractor, believe it or not, is now expressly permitted to file a claim if they disagree with the amount of a back charge for underperformed work. Again, this is something that I think was always implied and was sort of a constructive change before. It's just now expressed in the documents. In Article 3, the contractor's obligations, all the warranties have to be issued in the name of the owner and be transferable. It reduces the time for the contractor to provide notice of different site conditions from 21 days to 14 days, which is pretty, it's technical, but a significant change. It mandates a lot of details that are going to be included in the contractor schedule. It adds more lines and takes down to another level of specificity what's going to be in a contractor schedule.
Is that 2114 from the time they know or should have known?
Well, since you asked me, I'm going to make sure. Let's look and see. Let's see. I've got a 201 and we're in, is it 374? 374. Yeah. I know there's an article, but let me, because most of these I see have to be changed, so what the default term is often the hardest thing to remember. I can tell you what most people typically do. So it's going to be within 14 days after you first observe the condition. Okay, so once you've had some observation of it, not that it, and with a different site condition, no one's going to know until it exists. And otherwise, if it were 14 days from the time that it existed, and whether you knew it or not, every contractor would be giving a notice within 14 days of commencing the work, and just to hold it as a placeholder, which is why those more draconian or sort of gotcha notice provisions, as I call them, are really just going to. Most owners understand that all they really do is add paperwork to their plate. So you get more notices of things when people get worried about whether or not they have to give notice, then they don't even know about it yet. Good question. Okay, the contractor is going to have to provide their submittals in accordance with the submittal schedule, which is not really unusual. It expressly permits the contractor to rely on the accuracy of the performance design criteria provided in the contract documents. Again, I'm not sure that that's necessarily a big change. It also addresses certifications by the contractor design professional. So if a contractor's got its own design professional doing some design work, it talks about there's some changes, some new language about what certifications they're going to be providing about their work. Again, this document, like the design document, changes the fact that the owner and the contractor have to communicate to each other through the architect. The owner does have to notify the architect of all their communications with the contractor, however, even though the architect's not a party to any of these agreements. It allows the architect to order minor changes in the work, which I think has been happening for a long time. This just expressly acknowledges that architects are going to be doing that. But quite frankly, I think that's almost, if anything, helpful for contractors, because it makes it very clear that when an architect makes orders a minor change, that they had the authority to do it, and I was obligated to do it, and I get paid for it. And so the owner, you can't tell me that your architect didn't have the authority to do this, which is often one of the defenses you get from owners. I don't care what the architect told you to do. They should have told you to do that. I'm the one that directs changes. There's an express provision now, and again, this is another one of those expressly saying what has always been true. A contractor can object to the no charge, no time nature of an order for minor changes. It just turns a constructive change into something that has a contract provision that makes it tied to as an express change. Payments and completion. Contractor has to submit any changes to the schedule of values to the architects, not just to the owner. There's a provision there that requires lien waivers as part of pay applications, requires the contractor to indemnify the owner for any losses resulting from liens, as long as the owner has fulfilled its payment obligations. Good point. In some of I'm going to get away from the AIA documents for 1 second, but this occurs to me because I see it a lot. When you see a provision in a document that requires you to bond off and satisfy all lien claims of subcontractors, even for any reason, consider whether or not that makes sense in the case in which the owner hasn't paid you. I mean, it's one thing if the owner's paid you up in full and a subcontractor has some claim and you disagree with them, or you've got some dispute or whatever reason, and they're filing a lien and they want you to take care of it. Take care of your sub, I paid you. But when the reason is for non-payment, then that's a difference. And I think that it's important to get that qualifier in any agreement when you're talking about their obligation to bond off lien claims. The same is also true of attorney's fees. This is a great provision. I love owners when they put this in agreements. They put a provision in that says, if we have to engage an attorney to spend and incur any fees concerning any dispute arising out of this agreement, you're going to pay our attorney's fees. But what if the reason that you're having the dispute is because the owner isn't paying you? You've got to pay their attorney to defend them against you for seeking payment that they haven't made? That doesn't make any sense. A prevailing party attorney's fees is one provision is one thing, a mutual attorney's fees provision is another. But the requirement that you have to pay for their attorney's fees for anything that arises out of the agreement, whether it was their fault or not, doesn't make a lot of sense. And I think it's pretty reasonable to push back on at least trying to limit or qualify those kinds of provisions. The general conditions are finally going to drop the requirement that the certificate of insurance has to give notice to the owner of cancellation, which is something that has been sort of an issue and a problem forever, because no insurer is ever going to agree that they're going to be obligated to give notice to some third party, someone else, of the fact that there's going to be a potential cancellation of one of their insured's policies. It's been an impractical and unworkable contract term for a very long time, and they've finally gotten rid of it in this document, thank goodness. More on the 8201 on miscellaneous provisions and claims and disputes. It modifies the governing law provision to exclude the jurisdiction choice of law rules. That's a very technical legal change. It goes back to the discussion we were having earlier about the interplay between choice of law, jurisdiction, venue selection, enforceability of certain provisions in some states versus other based on where your contract is. It'll be very interesting to see how that provision gets interpreted, but I won't go into that level of the weeds of the legalities of it with all you folks. If you're really interested in something like this, I'll be happy to bore you with it. But it limits the initial decision maker's roles to claims, capital C, which is a little more limited role than they've had in the past for any dispute or any disagreement arising out of the work. It eliminates the role of the initial decision maker for claims discovered after the expiration of the period for correction of the work. So it's going to sort of sunset the initial decision maker's involvement in disputes that arise later on. And there's, again, more in the disputes. It modifies a little bit the process for initiating claims and establishes the place where the project is located for the place of arbitration if you're going to have it. So we're all coming here to do the project. If we're going to resolve a dispute out of this project, we're going to resolve the dispute right here where we all came to do the project. That's going to be the default. We're going to do it here. All right, so that was the 201. And very brief, I'm going to go through a few of the different changes in the A102. They're different from the 101. So these are many of the same concepts as what were in the A101. Many of the same changes that were in the 101 are also in the 102, including choosing the dates of commencement, having separate dates identified for substantial completion, the way the liquidated damages are handled, there's the same insurance exhibit, termination provisions, all that's the same. One thing that's different because the 102 is a different way of paying for the work, because it's a cost plus with a GMP rather than a lump sum, is that an owner has to authorize the revised contract documents to incorporate the agreed upon assumptions upon which the GMP is based. Everybody follow that? So what does that mean? What it means is that if you're going to have a GMP that is based on certain assumptions about the contract documents, because very often the GMP is established before the contract documents are in fact finalized, then they're going to have to authorize revised documents to incorporate those agreed assumptions. They're going to have to bring those assumptions into the contract documents, which is, I think, a good thing for contractors. Cost to be reimbursed. Most of these are similar to the costs that were there before. They've restructured and renamed them a little bit, and sort of reordered them and restated them a little bit differently, but the wages and salaries of supervisors and administrators away from the project side is now a cost of the work, and not just something that is a, it really was sort of a suggestion or an option in the old documents. It's included in the cost of the work now. Any incentive compensation, however, is no longer a cost of the work. Equipment and related expenses subject to prior approval if from the contractor or related party. So if you've got equipment that requires an owner's prior approval, you're going to have to get that in order to include it as part of the cost of the work. On-site office costs, finally get to the modern era, like office equipment and supplies, where it doesn't say things like fax and long-distance charges anymore. They've generalized and updated that. Most of this stuff on the payments is not all that interesting. Not surprisingly, progress payments are based on the schedule of values. but it has to include supporting data to substantiate the accuracy as required by the architect, whatever that means. You're going to submit supporting documentation to the architect to move costs from a contingency to some other line item. That's expressly stated in the documents now. And it clarifies that on retainage applies to the entire amount requested in your application. You can also exempt items from retainage expressly in the way the payments work. So there are a lot of changes in these documents. Not all of them are substantive. Some of them are just moving things around. Some of them are just adding expressly what has been otherwise sort of generally understood and been implied or been constructively included in these agreements. But the bigger challenge, I think, is going to be coordinating all the changes in the 100 series documents and the 200 series documents and the new insurance exhibit and the new digital data protocol and the new BIM modeling electronic data, is bringing all of those things together to make sure that they're in harmony and not just working on revisions or changes or tweaking any one of them, but what change you make to one is going to, since they've all been changed, going to affect changes you're going to have to make to all of them. And that's really the biggest, I think, just administrative burden that you are going to be facing in using these new documents. Questions?